Before we begin our final case for the day, I would like to inform all of you who are in the audience that the court plans to remain here so that we can answer some of your questions about the procedures that the court employs as we hear cases in oral argument, as you're seeing today, but also as we decide cases. The one thing we can't do is we can't discuss with you the cases that have been heard today or any case that's pending before the court. So we couldn't answer a question about who wins and who's going to win and who's going to lose in a particular case. But short of that, however, we would like to answer your questions. So if some of you in the audience have heard things that you don't quite understand or would like to have a little more information, be thinking of those questions and we'll try to answer them at the conclusion of the final argument for the day. The final case to be heard today is the Kentucky Unemployment Insurance Commission versus Landmark Community Newspapers of Kentucky Incorporated and others. For the appellants, Mr. Justice, I believe you have requested 12 minutes with 3 for rebuttal. Is that correct? And Ms. Green, I believe you'll have the normal 15 minutes. And counsel, if you would, perhaps include a little bit more facts than you might otherwise include in your oral argument so that the members of the audience will have a better understanding of the case. Thank you. Now, Mr. Justice, you may proceed.
May it please the court, Ms. Green. This case concerns whether Landmark's newspaper carriers and drivers are employees for unemployment insurance purposes. This case began as a result of unemployment insurance benefit claims being filed by Leonard Faulkner and Ronald Warner. These individuals were former carriers of Landmark, and when they were dismissed, they came into the unemployment insurance office and filed claims for benefits. On the benefit claim form, they have to list who their employer was. Both of them listed Landmark, or I think Mr. Warner put Standard Office, which is one of the other newspapers for Landmark. When the Unemployment Insurance Division began processing the claim, the first things that they have to do is determine that the claimants are monetarily eligible before you ever get to the disqualification issue to see if they're actually disqualified or not. As I stated, Landmark had been listed as the employer on the claim forms. In the processing of the claim by the Division of Unemployment Insurance,
I thought one of these people was trying to file an unemployment claim against his former employer, which was some government. I can't remember, city government or...
What one of them had a previous claim filed against the city of Bardstown. That was Leonard Faulkner.
For some reason, I can barely hear you, Mr. Justice. I don't know whether that's a...
Speak directly into the microphone.
Okay. Mr. Faulkner had previously had a claim that the city of Bardstown was the chargeable employer. Now, when he went to work for Landmark, he came in and notified the Unemployment Insurance Division that he was now back to work and no longer would be receiving unemployment insurance or needing unemployment insurance benefits. So he went to work for Landmark, worked approximately, I think, 3-4 weeks, something like that. And when he wanted to restart...
He's a newspaper carrier.
Yes.
That delivers the newspapers in his car from box to box out in the country. Is that right? Actually,
Mr. Faulkner was a driver who went to post offices, to businesses, and to coin boxes.
Okay.
And Mr. Warner, the other, was a home delivery carrier.
The principle would apply to all of these people that deliver newspapers? The principle we're arguing today?
The same factors and control and those issues, yes.
All right.
Yes.
But this one carrier we're talking about, he was going to work for his cousin. He thought his cousin was going to be sick for a long time, might never come back. So he was going to be the newspaper carrier. His cousin has an unexpected fast recovery, and 2 or 3 weeks later, he's out of a job again, so he goes back and tries to get Bardstown to pay him unemployment again. Does that?
Well, not necessarily. He did come back to reinstate his claim for unemployment insurance benefits. To do that, he has to file a new application and list his most recent employer, which was Landmark. That's pursuant to KRS 341.530. The chargeable employer for unemployment insurance benefits is the last 10-week employer. So he had to come back in and file a new claim to restart his benefits, but the issue then would have been who was your most recent employer, which division had to look into to determine who was going to be chargeable for these benefits. And stemming from that, also then, if he was working for Landmark, then there should have been unemployment insurance contributions paid on wages paid to him. So there wasn't any mistake. He was actually following the process when he came back in to reinstate his claim. He had to list who he most recently worked for, and then it would proceed from that point as to whether he was actually going to receive benefits or not, or reinstate his claim.
Well, and I'm looking at the appellant's or the appellee's brief on page 7 at the bottom where it says, at that time Faulkner attempted to reopen his prior claim against the city of Bardstown.
Well, actually, Your Honor, what he did, he came back in to reinstate his unemployment insurance claim. It's not Mr. Faulkner's decision, or it's by statute as to whether he's entitled to unemployment insurance benefits, and from that, then which employer would be, or which employer's account would be charged. So he might have had a previous claim against the city of Bardstown, but if there had been an interceding type 10-week employer that had come in, then that 10-week employer would have been the chargeable employer, not the city of Bardstown. So what happened in this case, he did have a valid claim against the city of Bardstown. Then he left when he was to work for his cousin, or he thought he was going to work for his cousin, but then Landmark required that he sign his own agreement to work for them. So he signed his own agreement pursuant to their requirements. So
Okay, I don't want to get you off of your argument.
yeah, so he came back, and so that was the claim process. As I said, the division was processing the claims, discovered that Landmark was not listed as the employer on the reports that had been filed with the Division of Unemployment Insurance. There are quarterly reports that have to be filed for tax purposes. Also, the division has to make sure that as I had stated, that the claimants are monetarily eligible. So when Landmark wasn't listed as the employer in their reports, but we had claimants filing unemployment insurance benefits claims saying that on the claim, which I think clearly sets forth their belief as to who they were working for, they said on there under penalty of criminal sanctions that they worked for Landmark.
Did they get a weekly or biweekly or monthly paycheck?
That benefits are paid every 2 weeks for
Say
unemployment.
benefits, was it salary?
Unemployment. Are you talking about when they worked for
Yes.
for Landmark? Okay, the home carriers received 7 cents a paper. Mr. Faulkner, who delivered to these post offices and business, he received $240 a week, is what his pay.
Would you call that straight salary?
For the home delivery, it's a flat rate of pay with no opportunity or no risk of loss. And I think under the case law, when you have those situations, it's more of an employer-employee situation where the carriers, it didn't matter whether the subscribers paid their for their papers or not, they were going to be paid.
Didn't well, not your clients, but the two applicants here, pay money to Landmark, who then gave them the papers? Is that the way it went?
No, Your Honor. These they did not pay for any papers. All they did was pick up the papers and deliver them. They did not collect any money, and they did not pay for the papers. It's not a situation where they bought the papers from Landmark and then tried to resell them at a profit. No. All they did was deliver it and get a flat rate of 7 cents a paper. In processing the claims, Landmark wasn't listed as the employer. So what the division, pursuant to its standard practices, what it does for every time one of these situations may arise, is it assigns an auditor to go out and investigate to determine why Landmark didn't list these individuals as employees. An investigation took place, and it was determined that not only did these two employees these two employees were not listed, also 21 others were in a category of contract labor. After the investigation, the Division of Unemployment Insurance determined that these individuals were in fact employees. A notice of assessment was sent for delinquent taxes and for past interest due, which Landmark appealed to the Unemployment Insurance Commission. The matter came before the Commission. The Commission is an appeals board that makes findings of fact and renders decisions regarding appeals under the unemployment insurance system. 2 evidentiary hearings took place, and from those evidentiary hearings, the commission evaluated the witnesses on their credibility. They made inferences from the evidence, and they also weighed the evidence and
Wasn't
rendered.
real clear about that. Was there a hearing officer, or did the 3 commissioners hear all the evidence?
Actually, the commission does not hear directly. What they do is they assign one of their hearing officers on their staff to go in, and then they review with the hearing officer the tapes and go over the summaries to make their final findings of fact. From that, I think this court has clearly given the commission guidelines when it deals with these independent contractor employee type situations as what to look to. One of the situations, like in the literal case from back in the 1950s, was that these situations have to be viewed realistically, considering the nature of the business and the services that are rendered. Also, under the unemployment insurance law, it's KRS 341.050, paren 1, paren A. The division has to look to the common law rules to make the final determination. In considering the common law rules, this court has directed that the restatement factors set forth in agency section 220 of the restatement be considered. So what the division did was it rendered its findings of fact, considered the factors that are set forth in the restatement, and made the determination that, in fact, the Division of Unemployment Insurance was correct, that these newspaper carriers are employees for Landmark, and therefore the contributions and interests were due. Landmark appealed the commission's decision to the Franklin Circuit Court, Judge Graham. This matter went before Judge Graham. It was fully briefed before Judge Graham. He applied the proper standard of review. He looked to see if the commission's findings of fact were supported by substantial evidence and whether it correctly applied the law, and issued his decision that, in fact, the division and commission had been correct, and upheld the commission's decision. Landmark then appealed that decision to the Court of Appeals. The Court of Appeals, after the matter was briefed and oral argument took place, rendered its decision stating that the facts are undisputed. So we didn't have any question with the facts. However, the court said that the commission and Franklin Circuit Court, by affirming that, had incorrectly applied the law.
Mr. Justice, you talking about the restatement second of agency, does the commission and does the law of unemployment compensation apply the same factors that are used to determine issues such as workers' compensation liability, vicarious liability for torts? Are these the same test that we use in those kinds of cases?
Well, Your Honor, I believe for the workers' compensation, there's a statute in place. Public policy has been set by statute by the General Assembly that newspaper carriers are employees for workers' comp purposes.
That's correct. But before that statute, with respect to other claims of independent contractors, I believe they use the same test that you applied in this case.
Yes, the common law factors are generally looked. In this state, all factors set forth in the restatement are evaluated to make that determination.
Suggested in the amicus brief that what this case is really about is not unemployment compensation insurance, but vicarious liability that might be imposed if one of these carriers, newspaper carriers, happens to run over somebody in their car while they're delivering the newspapers for Landmark.
Well, I believe that the factors would probably be the same as to that, but I think that what stems from that is you've got a different process for unemployment insurance with the administrative appeal.
I understand you're not the least bit concerned about that, but I'm thinking the next speaker might be.
Yes, Your Honor. What
could they have done to make them independent contractors?
What could they have done? Actually, Your Honor, what they could have done is not required or imposed themselves so much into the details of the work that was taking place.
Well, they just told them, we want you to go ahead and get these papers delivered by 7 o'clock. Obviously, they do not tell my newspaper boy that, but,
Your Honor, that's Landmark's position. That's exactly what Landmark's position is. That's all they contracted for. They wanted the dry newspaper delivered by 7 o'clock, and they didn't care how it took place.
How about if they sold them the papers and let the carrier set their own price?
Well, that would have been one of the elements that would have gone to more of being independent, as would have been the means of delivery, whether they should have taken it by vehicle, they could have
Mr.
walked
Justice,
it.
was there a written agreement between the carriers and Landmark as to the situation as to delivery and the other details that you mentioned?
There was a written agreement there was a boilerplate agreement that Landmark had that all the carriers signed.
When
It-
you say boilerplate, you mean a standard agreement that is...
Yes, it was a standard agreement that basically all they did was fill in the name of the carrier, and so the terms were not negotiated, and a lot of the instances that were asked
Well,
to actual
you
delivery.
could either agree to it or not agree to it in that sense.
That's true, but it comes from the fact that we have to understand that what we have in this situation are individuals who are looking for work, Landmark had put out advertisements, so what they obviously were seeking were individuals who were needing to work, so they brought them in. So when you have an agreement that they say, and I think that's what the commission determined, either they signed the agreement or they didn't work.
Did the standard agreement refer to the individuals who signed it as independent contractors?
I think they called them delivery agents, is the way it
Delivery
was.
agent.
Yes, I think it was called a delivery agent.
Counsel, there's an item or two. Obviously, control is a major factor to be considered, and location of employment is a big factor. I know that the agreement or that the terms of employment or independent contractor status required the delivery basically of a dry newspaper by 7 a.m. My question is, when and where were the newspapers picked up? Does the record show that?
It's in the transcript, Your Honor, that the papers were available between, I believe, 2 and 3 in the morning.
Okay.
Somewhere.
And at what location?
They were picked up at Landmark's location.
Okay.
Landmark had a coordinator
Now, these plastic bags that were furnished for use during rainy weather, they were furnished by Landmark also?
Your Honor, from the inferences that would be drawn, I don't know that that's technically in the transcript, but from what's been said and what Landmark, before the Court of Appeals admitted, that they provided like the tubes and the hooks, I think the inference is, and there's been no evidence that they provided anything these carriers did at all.
gas.
The gas, well, the gas is an issue that was in the contract. That was a boilerplate that said that they would be responsible for the gas. But we had testimony from Ronald Warner who and it only makes sense when you think about it, that 7 cents that was to cover the
I
expenses
wondered
also.
about that. You hardly drive from one mailbox to the next for 7 cents.
Yeah, I mean, obviously they were calculating the expenses into that, or they would maybe gone in the hole or something if it would have been that way. When it went before the Court of Appeals, they stated that the Commission had incorrectly applied the law. But what they looked to, they focused solely upon, and I think it's set forth in their opinion, they looked to the contract that had been entered. They did not look to the binding findings of fact that the Commission had entered that had been, and they had stated were undisputed, which are supported by substantial evidence, which do more than show what was in the contract. It enlightens as to what was actually occurring, and not only as to some of the terms of the agreement, but also as to, there were some terms or requirements that Landmark imposed that are not in that agreement, which go directly to control. Now, when you look to control, that obviously is the primary factor that this court has said to look to. When you think about this case, there's really not a whole lot left for these carriers to do as far as to the details. Landmark had extensive control in every aspect of the case. You can start from the designated route. The geographical area was set by Landmark.
Didn't tell them who to deliver to first or last, did they?
Well, that would only make sense not to, because as if you had weather conditions, road conditions, or something along those lines, how unless Landmark was going to be on the phone watching the weather or knew the road conditions every day, then they would not be able to get the papers to their customers on
Was it left
time.
up to the carriers how to deliver the papers?
No, Your Honor, it was not.
Just to get them there by 7 o'clock and dry?
No, well, that's what Landmark says, but actually Landmark called all the shots to get them there, and how they were going to get them there, and how they were actually to deliver them, and in what condition, which was a dry paper. And by that, I mean Landmark set forth the area, first off by designated routes. Inside that area, then they had a delivery list. And back to the route, I'd like to say first off, if you look to the Court of Appeals opinion, the comments to the restatement talk about how that goes to the employment relationship, that helps establish that. The Court of Appeals gave that no significance, but that's directly in the comments to the restatement. Now, within that area, you had a delivery list that Landmark controlled. They made all the deletions to, additions to, any changes to that. So within your designated route, you had these individuals that you had to go to. Now,
but what's the significance of that? Those are the customers. You wouldn't be delivering papers to somebody who was not a subscriber, would you?
Well, it's very significant, Your Honor, because it goes to what we're talking about here. Are these employees or are they independent contractors? Now,
Did they solicit customers?
no, Your Honor. And to the extent, the only way they solicited from the testimony would, Landmark also required them to, it was another paper that they had to deliver, which wasn't the actual paper. And they just dropped that off, and if someone wanted to sign up, they referred them to, and these were on the other days, to non-subscribers.
In
But-
other words, they delivered to everybody. Either you paid or you were a non-subscriber.
Yeah, but it was different type paper. One was the
Right.
actual paper that went out 3 days a week,
Advertisement.
and then an advertisement type
You,
thing.
you mentioned early on in your presentation something about coin boxes, and I was not clear about that. Did these delivery persons deliver to coin boxes also?
There were some drivers who took papers and dropped them into coin boxes, and that's what their role was.
And the evidence is, I assume, that the coin boxes belonged to the newspaper.
That's correct. These drivers had no investment. All they did was pick up the papers and go drop them off where they were supposed to.
Did they empty the money from the boxes?
Yes, they did. On the drivers who went to the coin boxes and businesses collected the money. They took all the money back to Landmark. They didn't take any cut or anything of their profit. The others collected no money. The home deliveries had nothing to do with any money at all. Your Honor, I think it was significant as to the delivery list as to why, you have the designated customers, you're right, for Landmark. But it's, as far as the employee situation is, if these were truly independent contractors, they should have been out there trying to solicit new customers so they could make 7 cents more. But they could not do that.
Let me maybe put you back on your argument too. What I think is your principal argument is this evidence may show that this male person, our newspaper person, is a employee, may show that they're an independent contractor. But the commission decided that they were an independent contractor, and that's supported by the record.
Actually, Your Honor, the commission determined they were employees.
I'm sorry, that they're employees, and that's supported by the record.
Yes.
And if that's supported by the record, then we have to affirm the
That's
commission.
the standard of review, Your Honor. That's always been the standard of review.
Well, are you talking about the facts or the law?
I'm talking about the standard of review from the facts. When you take the facts and you look to the factors, that's if the commission, in its role as the fact finder and to make the ultimate determination, made that and it's supported by substantial evidence, then the decision should be affirmed.
And remind me again what the Court of Appeals said, that the facts were not even in dispute in this case,
That's correct, Your Honor.
that the law had been applied incorrectly to the facts.
Correct. But when you look to the decision, if you compare the decision of the Court of Appeals to the decision of the Unemployment Insurance Commission, there are glaring facts that have either been overlooked or left out, and most of them go directly to control. Like, as I was mentioning, the delivery list, which is in the contract, which controls who they go to and how, delivered to, is not even mentioned in the decision. There was also, along this line, as to the delivery procedures that you had mentioned, Justice Keller, about how do they get the papers there. The contract said it was supposed to be done in a convenient and proper place, the delivery, to a convenient and proper place, which if you look to the contract is giving the alleged independent contractors great discretion to make that. It said never in a mailbox, but they should have had that discretion. But the commission's findings of fact, which are binding or substantial evidence, which are not in dispute, found that what Landmark actually required was that the carriers had to comply with the request of the subscribers as to where that paper was placed, which took that discretion away from the carriers. Supposedly in the contract, when you look to the terms, you would have that freedom. But in actuality, it didn't happen. And what happened if they did not comply with the subscriber's request or any other thing that happened? Landmark, and this is not in the agreement either, had a complaint procedure where they received the complaints. As Ronald Warner testified, he understood if he didn't comply, he was going to have to answer to the people at Landmark.
Counsel, your time has expired. You'll have time for rebuttal.
Thank you.
Thank you. Ms. Green.
May it please the court. Mr. Justice. Is this working? All right. The facts in this case are very straightforward. We have newspapers who have, which have traditionally used independent contractor labor as one of the means by which they deliver newspapers.
You need to speak into the mic.
I was humming.
Just get a little closer. Okay.
Thanks.
Move the mic over.
The two carriers who precipitated this whole case had both testified during the hearings of the hearing officer for the commission that they knew going into this that they were independent contractors. They knew that's what the deal was. Leonard Faulkner said his cousin had advised him of that. And Mr. Faulkner did indeed testify, the citation to the transcript is in our brief, that when he later went to the unemployment office to seek benefits, he thought he was seeking them against the city of Bardstown, which had been his last employer. In any event, this case puts the court on a well-traveled path here. Many times in the past, the court has looked at the legal standard that is before you today, and that is the restatement of agency 10-element test. There have been lots of cases where this court has looked at similar circumstances, not involving newspaper carriers, but other types of individuals who provided delivery services for some business, and has found on most of those occasions where there is as little control over the methods and means of the delivery service as there was in this case, that those individuals are independent contractors rather than employees. The Court of Appeals, when it was given this case, applied, of course, the 10-element restatement test, and it did so using the findings of fact of the commission. As you noted, it's expressly stated in its opinion that those facts were undisputed. It didn't disturb them. What it did, however, was correct the legal error committed by the commission and then adopted by the circuit court in its application of those facts. To examine that legal error and the reasons why the Court of Appeals was correct to reverse the decision, one needs only to look at several of the factors. Of course, each of these elements is examined in light of the facts applicable to each element to determine whether that element militates toward an independent contractor relationship or toward an employment relationship. When the commission made its determination, it acknowledged in its decision that there were some factors that militated toward an independent contractor relationship. It didn't discuss them. There were 3 elements of the test that it didn't discuss at all. The Court of Appeals, however, looked at all of the elements and forthrightly noted that while there were 2 that appeared to militate toward employment status and another 2 or 3 that seemed to the court to be a draw, that the balance of the factors, and indeed the most important factor, that of control, definitely militated toward the ultimate decision, the ultimate legal conclusion of independent contractor status. Factor 9 is one that I believe really highlights the error in the Commission's decision. Factor 9, that element, looks toward the belief of the parties. What did the parties think and understand as they went into this arrangement? Now, both the Commission and the Court of Appeals were relying on the same set of fact findings, notably that the contract contained language that did expressly say you're an independent contractor, you'll be responsible for your own
There's a difference
taxes.
between the Commission and the Court of Appeals.
Beg your pardon?
There's a big difference between the Commission and the Court of Appeals. The Commission is fact finders, or fact finders. The Court of Appeals, hopefully, is not a fact finder.
Absolutely, Your Honor. I agree with you entirely, and I think both of those agencies followed those roles here. The Commission certainly made findings of fact. The Court of Appeals accepted those findings of fact, and then when it applied those findings of fact made by the Commission to each of the elements of the test, there were numerous occasions
You're talking about the restatement?
of the restatement test.
Those
Yes,
elements
sir.
are facts.
Those elements, Your Honor, are elements of the test, the ultimate legal conclusion as to the status of the individual, and each of those elements is a piece of that conclusion.
In
So
determining whether one acting for another is a servant or an independent contractor, the following matters of fact are considered. So was the Court of Appeals finding fact when they come along and said, no, Commissioner, or were they saying the facts you found are not supported by the record?
No, I don't think they're saying the latter, Your Honor. I think what they were doing is taking the facts that apply to each of those elements and in some cases determining that the Commission had reached the erroneous legal conclusion as to that element. And in element 9, the belief of the parties, both the Commission, the Commission's findings of fact included such things as the language of the contract explicitly saying this is an independent contractor relationship, the fact that both Mr.
Well, I really wouldn't have expected Landmark to draw up a contract that says this is an employment relationship. And I wouldn't have expected Mr. Faulkner to understand when he signed a contract that said that I am an independent contractor, that he would have thought that he was an employee. That is a legal decision to be made by the Unemployment Commission in this court. I understand it's a factor, but, you know, the fact that Landmark had it in their contract that he was an independent contractor, that's a pretty self-serving factor to rely on.
And that doesn't answer the entire question.
Obviously.
I agree with you.
Obviously.
Was
Let me
there
ask you
anything
this.
in the record regarding the things like Social Security, payroll tax, and that sort of thing?
Yes, there is, Your Honor.
The individuals were required to pay that?
The individuals were responsible for their own payment of Social Security, income taxes. They were responsible for taking care of all of those matters related to their income. They did not receive...
What you would find on a Schedule C or CZ or whatever it is nowadays, and
Yes.
lawyers and others,
Yes.
businessmen.
That's right, Your Honor. And in fact, at the appropriate time, Landmark would issue to each of the carriers a 1099 report for their tax purposes.
But not a
just as
W-2.
not a W-2, but a 1099, as they did to any other vendor that from whom they obtained services.
They receive no benefits.
They received no benefits. They received no training. They didn't have day-to-day supervision. They didn't go to employee meetings or employee social gatherings.
Counsel, was the rate of compensation for various routes negotiable? Did it make a difference whether it was a rural or city route?
The newspaper calculated a rate of compensation which it believed to be a fair rate of compensation, Your Honor, and that was the rate that was written
This
into the contract and proposed.
This independent contractor did not have any negotiation on what he was paid.
Well, as the record shows, Laura Smith, who was the person that contracted with these individuals for this particular newspaper, testified that negotiation would have been acceptable, but no carrier had ever raised it.
So the rural carrier got 7 cents a paper and the city carrier got 7 cents a paper.
Well, you know, Your Honor, I'm not sure that that information is in the record. I know that the 7 cents per paper was the rate for the route that Mr. Warner contracted for. And I know that, according to our record, there was a flat rate that Mr. Faulkner contracted for the deliveries to the convenience stores and the like, where he would take
And
bundles
those two
of paper.
circumstances are the ones that we're under review today.
Yes, sir, that's
Only.
correct. That's correct. Those are the only two circumstances under review. The commission took these facts about the status of and the belief and the intent of the carriers and the parties, and rather than making its legal decision based upon those facts, it was swayed by a notion that it was somehow impermissible or improper for the newspaper to use a manual that set out the legal requirements in it. The Court of Appeals quite correctly reversed on that point, saying that there's absolutely nothing wrong with a company seeking to comply with the law and using resources that would enable it to do so. To say otherwise would be tantamount to saying that a lawyer who structures a corporation and consults with the or structures a public offering, say, and consults with the Securities Act and the rules of the SEC is somehow creating the kind of sham or legal fiction that the commission indicated it thought this relationship was. The Court of Appeals properly rejected that legal analysis.
On the other hand, counsel, it may be that in a particular case that it would be impossible to accomplish one's business objective and at the same time satisfy the requirements of a particular law. In other words, as applied here, the conclusion might be that it would be impossible for a Landmark to accomplish its business objective and at the same time comply with the law that maintains these carriers as independent contractors.
And
I know I'm not saying I agree with you, there's nothing wrong with trying, but it may be that the business objective and the legal principles are so in conflict that it just can't be done.
well, and that would be the reason, one of the reasons, Your Honor, for consulting a resource of that nature. If, in fact, you determine what the legal requirements are, and then you figure, well, our business objectives just don't fit within this framework, then you know you have to go to a different framework. You know, presuming good faith
lawyers
attempt to
get
comply.
paid to draw up documents to avoid taxes and to avoid estate settlements and dower interest and all this sort of thing. Sometimes they succeed and sometimes they do not. The question here is, did Landmark's lawyers succeed in creating an independent contractor relationship here, or did they fail and in fact create an employment relationship?
Your Honor, the question here is, what was this relationship? And I think under the law, it clearly was an independent contractor relationship. Looking at the realistic view of what was happening, rather than merely looking at the language of the contract.
Well, you can look at the language of the.
Right?
Big C for control, and not just control generically or control generally, but distinguishing between control over the results and control over the methods or means used to achieve those results.
What would happen to Mr. Faulkner if instead of wrapping the newspapers in cellophane on a rainy morning, he just decided, I don't feel like doing that today, and he dropped them at the bottom of the driveway like my carrier always did? So that when I got, and of course much later than 7 a.m., and I have Landmark, by the way.
That's the way Justice Cooper used to drop his papers when he was a paper boy.
Didn't know what kind of mood I was in, but suppose you found that out. Suppose the customer called up and said, look, my paper's been rained on 5 times in the last 2 weeks and has never been covered in cellophane. What would you suppose Landmark would do? Do you think they would fire Mr. Faulkner and get another, more compliant, independent contractor?
I think, Your Honor, that if the customer called the newspaper to complain, the newspaper would forward that complaint to the customer.
Oh, they would say to Mr. Faulkner,
to
if
the
you
carrier, excuse me.
if you don't start wrapping your newspapers in cellophane, you're going to lose a customer.
Well, what would happen, Your Honor? They may say that. I don't know, and the
doubt it.
record doesn't reflect it.
I doubt it.
But what would happen is that the contract specifically provides for termination of the contract if the carrier fails to perform.
In accordance to the way Landmark has told that carrier to perform. Get them delivered before 7 o'clock, put them in the cellophane bags if it looks like there's any chance of rain, put them in the little boxes the little blue boxes with that sit on the poles, or hang them on the hooks, and if you don't do any of those things, we're going to fire you.
All of those things, Your Honor, go to the result that Landmark wishes to achieve here, and that the carriers ought to wish to achieve as well, and that's to deliver to the ultimate user a dry and readable product. And if that doesn't happen, then yes, Landmark, under the terms of the agreed upon contract, can terminate the contract.
Counsel?
But that's no different, if I may, Your Honor, that's no different from an independent contractor that any of us might hire to, for example, be a handyman around the house, and we
Grass.
cut the grass, paint
Very
the house.
popular trade.
That we
I
would
have people who cut my grass, but they bring their own lawnmowers and they cut it whenever they get ready. They don't wait for me to tell them.
well,
They determine the price.
They tell you when they're going to.
Within reason.
well,
Well, you have submitted a legion of cases that have almost these identical factors that have also examined the restatement, who have found that these people are independent contractors. I mean, this is not the first time by far that these issues, and let's face it, almost all of these newspaper carrier cases have just about the same facts, and there have been a lot of courts that have held the way you're proposing.
Let
There
me
have been
ask you
an
a
awful lot, Your Honor.
hypothetical based on historical facts. When I was a paper boy,
Disputed or undisputed?
well, these are undisputed. When I was the paper boy back in the 40s and the 50s, we had to get the paper close to the door, and we liked to block the papers, and you could sail them and get some accuracy. But every now and then, we would be inaccurate and break a window. Now, who had responsibility for paying for that broken window?
Well, as an independent contractor, the carrier would have
Okay, so
responsibility.
the carrier doesn't pay, does the homeowner have a claim against the newspaper?
Homeowners insurance.
Well, Your Honor, we're going where the amicus brief wanted the court to go, and that really is not the issue before the court today.
I just want to know if I've got a claim against the Courier-Journal for all those windows I broke and paid for.
You know, I would have to guess, Your Honor, that the statute of limitations has run on that claim.
No, I may be under a disability. I may be under a disability.
That's an unknown fact, sir.
It can be determined.
In any event,
Counsel, is there any significance in the fact that the carrier was required to pick up the papers on the newspaper's premises, and that carriers were required to service, so to speak, newspaper boxes? Is that indicative of anything in this case?
Actually, Your Honor, the record reflects that there were multiple drop points for the newspapers after they were, the printing company printed
In
them.
other words, they did not pick them up
Some of them.
at the employer's premises.
Some of them were at the newspaper office, but there were other drop points as well, and that there was a 2 a.m. to 7 a.m. window there. And so, no, I mean, I think as a matter of convenience, they were put where they would be most useful. As far as taking coins out of the news rack boxes, in those particular contracts, that was one of the tasks contracted for. So what you have here is
1 minute, Counsel.
Thank you. Is an objective to get newspapers delivered to customers in a timely and readable fashion. The newspaper has not given instruction as to how you do that, in what order you do that, whether you do it right at 2:30 in the morning or at 6:30 in the morning, whether you bring your 5 kids along to help you or not. No instruction at all as to how that's to be achieved. And under these circumstances, we submit to the court that the Court of Appeals quite correctly determined that the proper legal conclusion here is that these individuals, under these circumstances, are independent contractors.
Thank
Before
you.
you sit down, if I may, just one, something nagging in both the Court of Appeals opinion and perhaps your brief about the number. It says there's a large number or a number of landmark newspapers. Are these throughout the state of Kentucky? Are they weekly papers or daily papers, or what kind of newspapers are they?
The landmark newspapers in Kentucky are primarily weeklies or twice a week, I believe.
With a shopper occasionally.
And the shopper is something else. I'm talking about newspaper
Does landmark own
publication.
papers outside the state?
Yes, sir. I don't believe any of that's in the record.
No, but it's not in the record, but it's.
Certainly, happy to tell
I didn't
you.
want to step on your closing.
Thank you, Counsel.
Thank you.
Mr. Justice, you'll have 3 minutes.
The first issue I would like to address was there was a question and a response dealing with the case law that has been cited. There are a variety of cases from all over the nation, I think, that both sides have cited that either hold independent contractor or employee. I don't see that there's any trend necessarily. It seems to be each case, as this court has ruled in the 1950s in the Locust Code case, pointed out, each case depends on its own particular facts. But more importantly, what's happened in this state, or what does not happen in this state versus other states, and what's going on as far as their determination, is a lot of the legislatures are actually stepping in and overriding the common law factors to a certain extent as to how these cases are decided. There seems to be limited statutory tests, maybe looking at 3 of the factors, maybe 4 of the factors, 5 of the factors, but in Kentucky we haven't gone there yet. The General Assembly still has enacted in 341.050 Pren 1 that all the common law rules are supposed to be looked at. So I think that's significant in that in Kentucky we're looking not at just 3 or 4 items, we're looking at 10 to 11 items, which obviously changes the complexion and the decision making in the case. There were cases recently, like was cited by the Appellee from Indiana, South Dakota, Minnesota. All those have limited statutory type legislatively enacted statutes, which has limited the factors to be looked at. And I guess we can't lose the perspective of what this is. This is a case that's stemming from an appeal of an administrative agency decision, which to this point there's been no dispute that it's supported by substantial evidence as far as the findings of fact, and that the agency applied the correct law. So from that standpoint, the cases are clear that the decision, when it's supported by substantial evidence, should be affirmed. However, that did not occur at the Court of Appeals. They, as I said previously, went outside or overlooked some of the facts, which went directly, as Justice Keller pointed out, those in the restatement are actually facts. That's not the law. Those are facts. The Commission found the facts regarding those and made the ultimate decision that they were employees. Counsel said that the Commission did not cite 3 factors in its decision. I think if you look to the findings of fact, you'll see that all the factors are touched upon in some manner. She didn't identify which 3 she was talking about. She also talked about that the Commission and Division did not appreciate or did not like their guidelines. That's not necessarily true. Commission has to look at this, as this court has instructed. They have to look at it at the substance, not the shadow of an independent contractor.
Thank
And
you,
that's what they
counsel.
did. Thank you, Your Honor.
Thank you, counsel.
Stay here.
Yeah. At this time, we're going to take some questions that members of the audience may have. I'll say to Mr. Justice and Ms. Green that if the 2 of you would like to gather up your things and leave council table and adjourn perhaps to the audience, that will be perfectly okay, rather than having you here on display, so to speak. First, let me say to all who are here as visitors today, we're really happy that you are here. To this group who sits near the front and on my left, I would like to say that your behavior and your listening and so forth has been excellent. I know that not everything that's been said here today has been fascinating at every moment, but we do appreciate your being here and you're having such good attention, and so we're glad that you're here. Anybody who has any questions about the nature of the work of the court, how we go about deciding cases, we would be happy at this time to attempt to answer your questions. Do I see a hand somewhere?